Greetings and welcome to Law and Life. Here, senior advocate, Supreme Court of India, Sudh Markandeji, discusses on the legal issue in India and fundamentals of law and many other such related topics. I am Shashank Mishra as a host. In this episode, we will be discussing on writ of habeas corpus in child custody case. Sir, my first question is there is so much buzz about the recent judgment of 14th July delivered by the Supreme Court of India in writ petition criminal number 402 of 2021, which was Rajeshwari Chandrasekhar Ganesh versus State of Tamil Nadu. What is your take on that?
So this case reiterates the well-known principles recognized across the Commonwealth, our common law jurisprudence, which is prevalent in India, US, UK, and so on. So the first principle which has been reiterated is that writ of habeas corpus will lie when a child is taken out from the lawful custody of the guardian and would be deemed in law to be set at liberty when the custody is restored to the guardian. So that's the first principle. The second principle, which has been reiterated in this case, is that habeas corpus child custody matters in these cases, the overall well-being of the minors is paramount consideration, overriding even the statutory rights under, let us say, Hindu Minority and Guardianships Act and other laws. So the overall welfare of the child is of paramount consideration. Nothing will stand in the way.
Sir, how old is this writ and when is it issued and when was it first used in the child custody case?
So the writ of habeas corpus is a judicial process which is very old and also efficacious. It's an efficacious remedy. So it is issued by the judge or the court on being prima facie satisfied that some person is in unlawful custody. If that is so, then the judge or the court will direct the person or authority in whose charge or custody such person is to produce him or her before the judge or the court for instant determination. That is, determination starts right there and then. Yeah, you can't postpone or adjourn it. Uh, what is the determination? Determination is about the uh, illegality or legality of such custody or detention. If the if the person is produced, the legality and or of detention is instantly adjudicated, and if it is found to be unlawful, the person detained is there and then set free. It's a writ of right. As far as I was able to find, the writ of habeas corpus was issued as far back as 1857. That is India's first war of independence against the British rule. So this is reported in Queen versus Clark, 1857, 119 English reports, 1219. So Lord Campbell, Chief Justice, wrote the judgment, and he said the child is supposed to be uh, unlawfully imprisoned if he is unlawfully removed from the custody of his guardian. And when delivered to the custody of the guardian, the child is supposed to be set at liberty. So that's the law. And it has stood the test of time.
Sir, what in your view is the crux of the legal principle that was applied by the Supreme Court in the Rajeshwari cases?
The crucial principle stated and applied in this case is that writ of habeas corpus in child custody cases is not in pursuance of to, but independent of any statute. The jurisdiction exercised by the court rests on court's inherent equitable powers. The court exerts the force of the state as parens patriae, that's the principle. That's the court court is in the nature of parents of the child for protection the child and his rights. The primary object of habeas corpus petitions as applied to minor children is to determine in whose custody the best interest of the child will be advanced.
So is Rajeshwari cases whose custody did the court release the minor and why?
The Supreme Court released the children, a girl called Laksha Ganesh and a boy called Bhavan Sai Ganesh, into the custody of the mother who had filed the writ petition in the Supreme Court under Article 32 of the Constitution. The court considered foundational facts, and more particularly that the petitioner mother had worked very hard in very trying circumstances to bring up the children. And respondent number two, that is the father, was always taking them away from mother's custody. The second thing which tilted the balance in favor of the petitioner mother was that father also flouted the agreement. There was an agreement arrived at between the parties before the American court where all the parents and children were there. That is called shared parenthood agreement. So he flouted that agreement which said that the children would not be taken out from the jurisdiction of the court. He brought them to India outside the jurisdiction of the American court, contrary to that agreement. And the third thing which also prevailed with the court was that father was repeatedly saying that mother is suffering from some mental disorder or disease, but he was not able to establish. Uh, so uh, her case was that his case was that her mental disorder, made her unfit to secure the children's custody, but he could not establish it. So the court gave the custody to the mother.
So what is the other outstanding features of this case?
Yes, there are some very outstanding features of this judgment. One is that it sets out a maze of complex factual metrics of the case. Then it considers the entire case law submitted both by the mother side and the father side in all its variegated complexity. And the third, uh, which was a determining factor, is that it gave, which makes the judgment very unique one, that it gave a series of directions, something like, in exercise of power under Article 142. The effect of those series of direction was to ensure that the children will receive the natural love and affection for both the mother as well as father. Those parents, who fight for custody of the children, they forget that, for the children, this rivalry is irrelevant. They want the natural love and affection of both the mother as well as father, which is very necessary for the overall well-being of the direction. So, of the children. So these directions, will ensure, or at least try to ensure as far as possible, that the children get the natural love and affection of both the father as well as mother. So these are the outstanding features of this judgment.
And thank you, sir, for joining and telling us all about this, sir.
Thank you.